Now, the Supreme Court will deliver its verdict on the validity of the BBI constitutional review process on notice. Chief Justice Martha Koome made the pronouncement on the third and final day of hearings. At the outset, the Muslims for Human Rights asked the court to uphold the High Court and Court of Appeal findings that the IEBC was not properly constituted at the time it carried out verification of signatures and forwarded the Constitution of Kenya Amendment Bill of 2020 to the county assemblies. Olive Burrows with those details.
On Thursday, the Supreme Court retired to consider the submissions made over the last 3 days on the validity of the BBI constitutional amendment process. The 7-judge bench did so after hearing from the remaining 3 respondents on Thursday morning before inviting responses from the appellants. In its submissions, the Muslim for Human Rights, Muhuri, asked the court to uphold the findings of the High Court and the Court of Appeal that the IEBC was not quorate when it undertook the process of verifying signatures for the BBI referendum push. They also submitted that there was inadequate public participation and that there was no legal framework in place to guide the verification process.
Did IEBC have a simple, accessible and transparent processes for signature verification that would enhance public participation in the process as envisaged under Article 257(4) and 5? The answer is no.
Justice Juma and Isaac Ogola, on their part, supported the High Court and Court of Appeal findings that the delimitation of boundaries is a protected function of the IEBC.
So who was this telling us that Siaya County required this number of constituencies? Who was that?
Kituo Chasheria was the last of the respondents to make their submissions and called on the court to protect the sanctity of the Constitution so it doesn't suffer the same fate as the Independence Constitution.
We have now current politicians, and there's very little really to admire them for. Most of them, you get the impression that they are job seekers, they are office seekers. And they come up with things like amendment of the Constitution because they want to continue to be in power.
In its response, the Office of the Attorney General defended the President's right to initiate changes to the Constitution and contested the threshold set by both the High Court and Court of Appeal on changes to the building blocks of the Constitution.
Article 131 of the Constitution confers upon the President certain functions, the performance of which may potentially include amending the Constitution in order to, 1, safeguard the sovereignty of the Republic, 2, promote and enhance the unity of the nation, 3, promote the respect for the diversity of the people and communities of Kenya, and lastly, ensure the protection of human rights and fundamental freedoms and the rule of law.
The Supreme Court again finds itself in the middle of a politically charged situation, with a general election a few months away and with a new president heading the court.
But your deputy,
a new president whom some fear lacks the conviction and courage to carry forward the independence the judiciary had won from the executive.
The judge under the Constitution 2010 is a lion or lioness. You are expected to roar the constitutional truth. You are expected to say it like it is.
And so it's not just the BBI on trial, so is Martha Koome.
The decision of the judges is that the judgment will be on notice.
Olive Burrows, NTV.